Hello everybody, my name is Ruxandra and welcome to another video of R&R Partners. Today we're going to talk about recognizing foreign court decisions in Romania. So what does this exactly mean, recognizing a foreign court decision? It means that once you have a decision, for example, a divorce case or maybe some sort of custody case or something in the commercial area, then you can get that decision that is from another country and enforce it on Romanian soil. So basically the effects of this court decision become applicable in Romania as well. But they do not become so in most cases automatically, but we must go through a specific process to get that done. So you can acknowledge the decision of a judge in another country and the effects of that judgment in Romania, but usually that is not done by going through the case all over again. A judge in Romania will mostly not go on the merits of the case, but rather recognize that the court decision from another country was taken in a specific way, and the effects of that will also be in Romania applicable immediately. Then once the court decision from another country is recognized, only then can you actually enforce it here in Romania. The only exceptions are decisions about the personal status of a person, which do not have to go through the same procedure, and you can skip that. In other words, you can jump directly to enforcing that court decision once you are here in Romania. So, what kind of court decision can you recognize in Romania? We can have mainly two types. We have decisions that are taken when the parties are on the contrary positions. For example, if you want to divorce your spouse and you do not agree on all the terms of the divorce, or maybe if you want to have enforcement of a decision from which you get money from another party, either an individual or maybe a company. That is the type of decision that is taken in a contradictory proceeding. But we also have the second type, which is non-contentious procedure, what we call non-contentious. That is a type of decision where the parties basically agree on the merits of the case, and it's more like an administrative procedure. For example, if you go in court to have your name changed. Those are decisions on the status of a person in another country. For example, regarding your name, or if you got married, divorced, or any other changes regarding your civil status. And you also have decisions that were issued in another country, but those must abide by three rules. The first rule: these decisions were first recognized in the country of each party, or if they were not recognized, they were delivered based on the applicable law according to Romanian international law. The second rule: these decisions are not contrary to public order in Romania regarding international private law. And thirdly, the right to legal defense was observed. All this might sound like very technical things, but I can assure you a lawyer who takes care of your case will know all of these, or should know at least. The idea is that the law is kind of strict because we do not want to take some sort of advantage from getting a decision in a state where the human rights, for example, are not observed. As I mentioned, you must have the right to defend yourself for the second step. You cannot have such a decision taken in another country and just enforce it in Romania, because it's very probable that if you came to Romania in the first place, a judge would not issue this kind of decision. They would not agree with it. And coming back to the more legal and technical thing, after we completed the step of full recognition, we must also think about the kind of decisions that are not fully recognized in Romania but are conditional. The conditions are that the decision must be final in the country where it was issued, that the court in question was competent to issue that type of decision, and the countries mutually recognize their judgments. Which makes sense, because if country A does not recognize decisions coming from the country B, why would country B do the same thing when a decision from the other country comes to them? Another special case that we must talk about is when a decision is issued when one of the parties is not present. If they lost the trial and they were not present at the trial, certain conditions must be met in order for that decision to be recognized in Romania. Those are that the party was legally summoned for court, that the losing party received the documents in question and they had the legal right to defend themselves and also the right to an appeal. So how do you actually make a file for recognizing a foreign court decision? It will usually be a standard petition. You can find more details about it in the Romanian Civil Code, and it must contain all the standard information in order to be considered an official court petition. You might also want to know which court is competent for ruling on such a case. You also have the court from the domicile or the offices of the party that is the defendant. So if you sue your wife, for example, who is in Romania, then you must have the court at her domicile competent. If you do not know the domicile or the official offices of a company which you want to sue, then you will go to the Bucharest tribunal and there you will plead your case. And finally, for your case, what kind of files should you enclose? Because your file must have quite a bit of documentation to show that the foreign court decision must be recognized in Romania. First, you'll have a copy of the official court decision. Secondly, proof that that judgment is indeed final. Then proof that the court made the summons correctly and the person in question really got documents from court. And any other documents that the court might think are necessary in order to show that you are abiding all the legal conditions in order to recognize your foreign court decision. Very importantly, because we are talking about a foreign court decision, all the documents that you submit must have official translations and should be legalized according to the Hague procedure with apostille if necessary. Depending on the case, you can also have over legalization if the Hague apostille is not applicable. The only exception is when you have countries that mutually recognize their court decisions. For example, Romania has that kind of treaty with the Republic of Moldova. We recognize our decisions mutually, and this can cause a very good effect in court. You don't need all that paperwork in that case. So this is about it for today regarding recognition of foreign court decisions in Romania. If you like this video, don't forget to give it a big thumbs up and subscribe to our channel because we have many more videos about commercial and immigration law coming up. And if you have any aspects that you would like us to address in our future videos, please leave us a comment down below so we will know what is most interesting for you guys. And if you have any ideas for our future videos, any subjects that you would like us to talk about, you can leave us a comment down below. And don't forget to follow us on social media. We are quite active on Facebook and Instagram if you want to find more about our content and also our events online. Up until next time, have a great day. Bye bye.